Okay, I think we'll get going now. So, hey guys, so today we're talking about GDPR, which is going to affect everyone on Travel Massive, essentially. So I'm glad to see so many here. Paul has been doing a huge amount of work on GDPR lately for our own company, In Marketing We Trust, who's the sponsor of these Travel Massive live events, in case you didn't already know. And we've also got Tim Bell with us today, but I might just let you guys introduce yourselves, actually. So I think you can probably do a better job of it than I can. So take it away.
Kirsty. Thanks, Kirsty. So yeah, as Kirsty said, myself, Paul Hewett, and Tim Bell. So just before Tim introduces himself, just a small story that's basically data marketer and a legal guy. We walk into a bar in Texas. Tim has just done a presentation on GDPR at South by Southwest, and I was in the audience, and we could see everyone's jaws hit the ground when they realized the obligations that were heading their way. And Tim and I got talking, and having been involved with Travel Massive, I thought it was a really, really good opportunity to bring Tim's knowledge and my knowledge on GDPR to this forum. So that's kind of how this all happened. It was done. The fact that we're both English is just coincidental. Yeah, Tim, do you want to introduce yourself?
Yes, absolutely. Hello, everyone. So I'm Tim Bell, Managing Director with DPR Group. As Paul said, we met after I delivered a session on GDPR in Texas, and it's always interesting, I think, to see people's reactions when they find out that the new European laws can affect them as well. But we'll go on to that in a bit, and I'll let Paul take it on the first section.
Great, thank you, Tim. Okay, just a bit of a disclaimer. So this is a general presentation on GDPR, and it's aimed to help you move towards compliance, and we're going to help you kind of identify some of the risk that you may be exposed to. And anything that you hear in this does not substitute for legal advice. Okay, so it's really important that we get that across. And actually, if there are any questions in this, we'll happily answer questions either at the end of the presentation or via emails. But if there's a particularly tricky issue, then you must take legal advice on this. Okay. So what we're going to cover today, we're going to look at why GDPR matters to non-EU companies and why it matters to travel companies. To warn everyone, we've got a hell of a load of slides. Okay, so what we're going to try and do is we're going to try and get through as many of these as fast as possible. And I suspect you'll all have lots of questions at the end, so please make note of those and as we go, and you'll have the opportunity to ask when we get to the end. So the first thing I want to get across when we're talking about data, I mean, we love data. Okay, so personal data. As marketers, it's kind of the lifeblood of what we do now. Most of the things that we do is data driven, but also we understand that consumers want the right to protect that. So everything that we're going to talk about is in a really positive light. We want to get hold of data, but we want to use it in the best possible way. So just to frame the conversation, the amount of data that we are collecting at the moment is just the tip of the iceberg. It's growing day by day. And the type of data that we are collecting is continuing to change. So currently, we're mostly capturing structured data, text, that kind of thing. But as you'll see in a moment, we're actually moving into a new era of data collection where biometric data is being collected on a personal level and stored on a personal level. And to give you an idea of where we expect that to be by 2020, we're looking at zettabytes of data. So basically, the amount of data being collected at this point in time is equivalent to an audio recording of every single word spoken by every human ever. That's how much data is being collected at the moment and stored at the moment. So we're talking about vast amounts of data that is going to be growing at an exponential rate, and a lot of that data is going to be pinned back to people. So things like videos, photographs, or biometric data, facial scans, all of that sort of stuff. And to highlight that, I wanted to just kind of pick out some of the things that we're seeing in the industry at the moment. So if any of you are big technology fans like me, you'll be watching Alibaba closely. And in this picture here, on the right-hand side, we've got a picture of Jack Ma showing the facial recognition technology that Alibaba is launching. And they've actually got a number of subsidiary companies that are using that data for commercial purposes. So in China recently, the first Smile to Pay application was launched. So most of us are probably aware. I'm going to admit now, I go to McDonald's on a regular basis, and if you saw me, you wouldn't be surprised. But you'll be aware of the screens that we have in most McDonald's these days that are replacing cashiers. And Alibaba's technology allows the consumer to smile to make that final payment. So it looks at your facial movements, it looks at your smile, it looks at your teeth, and is able to gauge whether it's you. The technology, I was looking into it, is actually very robust. You can't trick it with pictures. It needs a real face. So, I mean, that's very exciting, but also very scary, because where does that data go, and how is it held, and how long for, and lots of questions about that. And then the final picture is just something that we're all familiar with, which is biometrics in airports. Obviously, that's a huge part of kind of the travel experience now. So bringing this a bit closer to home, I've got a couple of slides here. This is some work that Expedia has been doing. So they are using the facial, not so much facial recognition, but the eye tracking, basically, to figure out what part of a digital experience you like, and then craft a bespoke holiday for you. But again, the same questions apply. When your camera kicks in and it tracks your eyes and your face, again, what processes are sitting behind that to, is your whole face being recorded? Is it just your eye movement that's being recorded? And again, we have the same questions of, where is that data kept? How is it processed? How long is it kept for? Is it appended to my IP address? All of those things. And this is primarily what GDPR is concerned with. So very quickly, just an example of when data goes bad, personal data. This is a real world scenario happening in 4 cities in China at the moment. So heavily surveilled population, and the cameras are actually tracked with using facial recognition. And they're being used for things like picking up minor infringements such as jaywalking. So in the top left-hand corner, we've got a member of the public who has jaywalked. They've scanned his face, and not only do they publicly publish that on social media and at tube stations, that facial scan is appended to a criminal database. Yeah, so that's obviously not a great thing for the citizens of these 4 particular Chinese cities. So now on to Tim's section about data breaches.
Yes, absolutely, and this will be something that I imagine is very familiar to all of you. And rather than looking at some of the cases in Facebook's history, which are actually not necessarily long distant history in some cases, and how particularly Max Schrems, who's a privacy activist in Europe, how he's been really seeking redress from Facebook in Ireland for a number of years. But we've seen over the last month the Cambridge Analytica issues and everything that's been happening around that with Facebook. And that's not only shown the risks to business as far as costs, and we saw actually the value of Facebook drop by 50 billion, which is an extraordinary amount of money, off the back of those revelations of what was being done with the data that Facebook was providing to their contractors. But also it's created a loss of face. It's a loss of respect and a loss of trust for those customers of Facebook, who are now thinking, actually, can I trust this company with my data? And what are my alternatives? And as soon as you've got consumers being concerned about how the data is being treated by a company, that's when they're going to start looking around at alternatives. And there's been a number of other cases in against Facebook. You'd be familiar with the Snowden ones, I'm sure, where Snowden actually revealed that a lot of the information that's coming into the US, including those the data that Europeans provide on Facebook, that was actually being surveilled by the NSA and details kept on that. And if we can go on to the next slide, we can see WhatsApp, which is in fact now also a subsidiary of Facebook. They got in trouble in Holland a couple of years ago for not appointing a local representative as part of the Holland's enactment of the of the previous regime of data protection laws. They received a 1 million fine in euros for that. And then last year, and this was a really interesting one with the connection between WhatsApp and Facebook, the fact that WhatsApp, although a very safe and encrypted platform, was sharing the data that they were seeing on their platform with Facebook, who were then issuing adverts to those individuals. So if you were chatting to a friend on WhatsApp about wanting to go on holiday to Germany, let's say, suddenly you'd be finding adverts for German holidays on your Facebook profile. And then moving on again, the Uber breach and the massive Uber breach that happened, and the fact that Uber had to eventually put their hands up to it. That type of issue, were that to happen under GDPR, and we'll see in a minute the risks that come with that, but the fines would have been quite extraordinary. And I mean, certainly it's not over for UBS on this. They haven't fully faced the music on it, but it's nowhere in the same scale that it would have been had this type of event happened when GDPR was in place. So what is GDPR? And this is the key question, and how does it affect you? And those are really, I'm sure, what people are really keen to hear. GDPR is the new European law that's been put in. It's a regulation, so it applies directly to all European countries without them a need to bring that into law separately, although many countries actually are doing so. And it benefits all individuals within the EU. Any person who's in the EU, and that's not just European citizens, but also citizens of other countries who are based in the EU at that time, are protected, and their personal data they now have, or they will have, with effect from the 25th of May, only now 16 days away, they'll have a certain number of rights in respect to their data, and they'll be able to exercise those rights and complain to the local EU authorities, who will take up that cause for them. It replaces the 95 Act, and that's sorry, thank you. The old regime was created in 95, pre-internet really. I mean, the internet was at very early stages, so none of this volume of data, the zettabytes that Paul mentioned, none of that was a reality at that stage. So it was very much a need to bring it up to date. And here we are, 2 weeks on Friday, and we're going to be facing the reality of that GDPR situation. So, and this is the key, and this is absolutely the key. I'm sure many in the audience here aren't from Europe, probably the majority. And the key thing is that it is directly enforceable against you in your own countries. And what will happen likely is that the method that this will be achieved is the individual will bring their concerns to the local EU authorities. Those authorities will then look into those issues, and if they decide that GDPR has been breached by a company outside of Europe, then they'll be placing fines on that company, potentially placing other penalties, and then looking to enforce those in the local courts in those jurisdictions. And the key thing will be that those jurisdictions will politically find it very hard not to enforce the GDPR rights, because each of those countries, in order to trade with Europe, needs to have a legal structure in place that enables them to enforce data protection laws. And any country which is seen as not enforcing data protection laws will likely find it very hard to do business with Europe in the future. And the key part of this that identifies this territorial scope is Article 3.2. So Article 3.1 identifies that companies in Europe are affected by GDPR, and that was always apparent. But Article 3.2 says that if you're a company based outside of Europe, if you sell products or services into Europe, or if you monitor individuals in Europe, and monitoring there is quite a wide description. It includes simply as much as putting a cookie on your website and monitoring what pages people are looking at and possibly where they're based and how long they're on your website. Because you can use that IP address information to trace it back to the individual, you'll be monitoring that individual, and those acts in themselves, even having a cookie on your website, will likely place you under the regime of GDPR. And this is the really key bit. This is the bit that usually makes the jaws drop to the floor, and the certainly senior executives in companies start sweating quite heavily, is the massive fines that are potentially there. The fines, as you see on the side, but it's worth saying out loud just to be clear that these are actually genuine. Up to 20 million euros, or 4% of global revenue. And it's the greater of those two which is the effect. So if you've got a company which brings in billions and billions, then your potential fine could be absolutely massive. And the reason for that is that the Facebooks and the Ubers and the WhatsApps of this world, unless you have a sufficient penalty that's actually going to make them take notice, it's going to be really hard to actually make any of them pay attention. And this was the problem with the old regime, that the penalties and the fines were actually very small. So it was really worth, Facebook would do better from scraping that data and treating it in the way that it has and paying the fines afterwards than they would have done from acting in the correct way that they should have done in the first place. And I think the next, in fact, this is a great slide here. This is an example of the kind of fines that some groups of companies could face. So where you do have companies who have a turnover of a certain level, that 20 million is the maximum. But as soon as your group's profit starts to creep into the potentially tens and hundreds of billions, then you can be looking at a fine, when you're looking at 4% of global turnover, that really is very sizable. I mean, look here at travel companies like Expedia. When you look at the overall profit of their group in the last year, the 4% would equate to around about a $2 billion, beg your pardon, fine. And Google, as I'm sure you're not surprised, with the size of their organisation and Alphabet and as the parent company, their fine could be looking at over $4 billion. So it really is something that makes people take notice. And the intention really is to enforce globally. And this, it really can't be overstated. This is one of the prime drivers from Europe in bringing the new regulation in, is that they realise they can do whatever they want in Europe, but unless they can actually bring some force to bear on the Facebooks and the WhatsApps, it really offers very little value, because so much of that data is now outside of Europe, and they'll be doing their absolute best. They'll be using every method that they have available to make sure that they're enforcing it against companies around the world. And that's the key. And this is really what we want to make clear on this presentation. It is a really big point that I like to bring at every stage, is that GDPR and observing your customers and your data subjects' privacy rights is a fantastic opportunity. This is something that consumers are going to be increasingly looking at when they're deciding which supplier to purchase from. And if your organisation is the organisation that presents the gold standard for privacy, that has the very best data security and the best consents, the best ways of dealing with their customers' data, then that is going to be a significant advantage to those companies when they're going out to the market and attempting to sell their products. The really key thing is, make sure you're asking your customers for consent. Tell your customers what you're going to do with the data, and tell them how you're going to protect that data. And this is really some of the key bits about GDPR, is making sure those individuals are aware of what you're doing and that they have agreed that you can do what you are then doing with their data.
Okay, so we're going to have a look now at why travel websites and companies should pay close attention. So just quickly looking at a small example of the travel market. By its very nature, the travel market is a global market. So if we look at this example of Singapore here, where we've got theme parks, car rentals, hotels, by being travel businesses, they're actively targeting people in Germany, in United Kingdom, in Spain, all within the EU bloc. So the travel industry, from my perspective, is quite a high risk from a GDPR perspective. So even companies with a country-specific top-level domain. So this is a real example here. So in this particular case, this is a company that has a .co.uk, .fr, .sg, .cn, .com.au. They've got a really good global setup for their website. But if you look at the .com.au, you can see that EU users are still creeping into that. So in this instance, we've got 1,733 European users finding their way to the website each month, which doesn't sound like a problem until you look at the cookies that are being fired off. So typically with most websites, you have your analytics one. So if you're using Google Analytics or Adobe Analytics, usually that data is absolutely fine. There's a note against that in a moment. Because the data is anonymized at the point of capture. Okay, so there's no IP address. You're not capturing personal information. You're not getting an email address out of it. You're anonymizing the data at the point of collection. But then there are three further types of cookies, and the worst kind, really, from a data protection perspective, are any form of personalization and advertising. So for instance, if this company does fire cookies that will, they've got DoubleClick, they've got Floodlight, they've got Criteo, all of these advertising and remarketing cookies, they're actually collecting personal data. They're monitoring where they're moving on the website. They're monitoring other web activity, and they're serving ads up based on that data. In this instance, even though this company has got a country-specific top-level domain, they're in breach of the data GDPR. So the note about PII data. So again, this is a different company now, but PII data, your analytics data cookie is fine normally, okay, as long as it's set up in line with the Google terms. However, most of the websites that we see these days are actually pulling personally identifiable information into the analytics setup. So in this instance, we've got passwords, we've got usernames, we've even seen telephone numbers, we've seen gender, we've seen it all. In Google Analytics, because people are doing complex form setups, they're syncing the data with their CRM, and as a result, in this particular instance, yeah, we've even got transaction amounts in there, so how much that person is paying, and we've even seen very recently amount and the person's address, the person's telephone number. So the point is, this is a data protection breach. By the EU standards, you will get fined for this, but worse than that, well, not worse than that, but on par with that, it's against Google terms. And what Google will do if they spot this, and they're getting better at spotting it, is they will terminate your Google Analytics account and they will wipe all data out, and they won't give you any notice of that. So even if you've got 10 years data, hundreds of millions of sessions, that data is gone and there is no retrieving it, okay? So one thing I would warn is to get your web analytics company to have a good look in your web data and make sure that you're not capturing any personally identifiable information within your GA account. So what you need to know about GDPR as a non-EU company, okay? So I'm going to very quickly go through a few principles here. So the data subject is the owner of the data. So there's lots of terminology within the GDPR, okay? So the data subject is the person, the owner of the data, and they have rights. And then on the other side, you have processors and controllers. The controller is the person who collects the data, and the processor is obviously the person who processes the data. So processing is a very broad remit, so it covers everything from making amendments to the data, storing the data. Again, pretty much anything that you're going to be doing with that data is classed as processing. So one key concept that I like to use is the data subject is, in most cases, there is a number of reasons why someone can collect and process data. But if you're working on a consent basis, the data is owned by the data subject, the person, okay? And the controller, which may be a company, such as a hotel or a travel blog or whatever, the car rental company, that controller is just borrowing the data from that person. And by borrowing it, obviously you have to tell that person very, very clearly what you're going to be doing with that data and who you're going to be giving it to. So if you're going to be using it for email marketing and you're going to be giving it to a processor who does that for you, then you need to be very clear about that. And the system works that if there is a data breach of any way, it goes back up the chain. Ultimately the controller is responsible for that, and the controller should be making sure that any of their processes are abiding by the GDPR. So very quickly, what is a data subject? So there's quite a broad, not broad, but a long explanation of this. Basically, it's a human. So it's any natural person. And that person has 8 rights under the GDPR. So they have the right to access their data. And Tim's going to go a bit more into subject access requests in a moment, so I won't go any further on that. They have the right to rectify their data, so tell you kind of, look, you've got this wrong, you need to change part of that information that you hold on me. They've also got the right to erase the data, so that's typically called the right to be forgotten. They've got a right to restrict your processing of that data. They've got the right to be informed, so they have to be informed of what you're doing with that data. And they've also got the right to data portability, so they can ask for that data in a readable format, so they can move it around as to another provider, for example. And they've got the right to object and the right to object to any automated decision making as well, which may happen in the processing of the data. So the principles that the GDPR is based on is lawfulness, fairness, and transparency. And that's normally where I spend a huge amount of time talking to customers about this, and talking to people about this. For me, this is one of the core principles. If you know that you've got a legal basis and it's fair and it's transparent, a high proportion of the work is already done. And then purpose limitation. So being very, very specific about how you're using that data and what you're using it for. So if you intend to set up an email campaign for at the point of collecting data, or someone signing up to an email newsletter or something, that's fine. Send them that email newsletter, but then don't use that email for other forms of profiling or something like that. And if you do intend doing that, you have to be upfront about it, okay? Then data minimization, so making sure that you're only collecting data that's relevant to the purpose, okay? So if you need an email address and a name to run an email campaign, then just collect those bits of information. Don't collect things, additional information. So many websites have progressive profiling on them. which is fine if you're going to use that data for something specific, but you have to be very careful that you're not asking for irrelevant data. So making sure that the data is accurate and up to date, and making sure that you've got processes for that, actually, to make sure that you've got a log of the amendments which are being made. So then storage limitation is about holding the data for only as long as is necessary. And that's going to vary hugely depending on the relationship you've got, the type of data that you've got, but basically having a process to know how long you should store that data for and at what point it becomes irrelevant, and then the process for wiping that from your systems. And then integrity and confidentiality is just making sure that you take all of the measures to secure the data to an appropriate level. So those some of the data breaches that Tim mentioned earlier, obviously some companies are going to be more open to hacking than others, but obviously as a technology company or a travel company, you'll need to make sure that your data is well protected. So an example I like to give to this, particularly for people like travel bloggers, is making sure that if you've got a bunch of users on your website and you're using something like WordPress, then make sure that you're doing the security updates. I mean, if you're not doing the security updates on your WordPress website, then you're not protecting that data. So accountability, be responsible and demonstrate compliance. Demonstrate compliance is a really, really key phrase, and we'll come onto that in more detail when we get to the point of what to do about GDPR, which will be in a few slides' time. So over to you, Tim.
Yes, absolutely. So fantastic. And this is, I really echo Paul's words here earlier in the disclaimer that this isn't full and formal legal advice. And I'm going to talk about some of the obligations under GDPR. And these are really some of the key headline obligations. There are more, and there is more detail. But certainly these are some of the key issues that you should be aware of, and really some first points to try and make sure that you're working towards, so you can show that you are doing your best to be consistent and compliant with GDPR. And the first one is the rather nebulous description of the need to have privacy by design and default within your company. And I like to think of this as more of a state of mind than law. It's really about having a culture in your business that places the protection of your customers and your data subjects, your users or subscribers, whoever they may be, protecting their data and their rights as really the fundamental point of any of the actions that you're going to take in the course of undertaking your profession. So whenever you're working on a new process, or wherever you're thinking about a new way of dealing with your the personal data that you hold, the first question that you're always asking is, how do we protect these individuals' rights? How are we going to protect this data? And how are we going to make sure these individuals' privacy is protected as a standard, as a default for those individuals? And the next one, we've got the lawful basis for processing. Now, this is one where a lot of people tend to get concerned about the idea of consent, and consent is really important and is generally considered to be the main point, the main basis of lawful processing, but it isn't the only one. Where you are seeking consent, though, and certainly for many travel organisations and for marketing particularly, consent will be very important to obtain, and it's now a higher bar to get over to achieve a full consent. It needs to be freely given, specific, informed and unambiguous. So when you're giving that consent, or rather when you're seeking that consent from your data subjects, you need to be telling them everything, as Paul mentioned before, that you're doing with that data. And this comes back to those original principles of making sure that you're informing the individuals and making sure that they're agreeing that you can use the data in that way. And the pre-tick box of old, the way that that many companies have historically dealt with consent, where there's a pre-tick box and you need to untick it to say that you don't want to get onto the newsletter list and what have you, that's no longer acceptable. You need to make a clear action So either to tick that box or to untick that box in order to give your consent. So you can't just have it as a default. It needs to be an actual action taken by that individual. But as I said before, there are other ways of having a lawful basis for processing. It isn't just consent. If you've got a contractual obligation to an individual, let's say if you've sold them a physical product and you're sending it to them in the post, you will need to use their address in order to actually complete the contract you have with that individual. So in that case, it isn't actually specifically necessary to obtain their consent, because you need to use that data. You need to process that personal data in order to complete your contract. If you have legal obligations, so if you're a government body or something like that and you need certain information on people, or an issue that's of vital interest to an individual, so say if an individual was injured and needed to be treated for medical issues, then that individual's vital interest would override the need to get a consent. And likewise, public interest, if there's a general benefit to everyone, then that can be a lawful basis. And the legitimate interest basis is a really difficult one, and I certainly wouldn't intend to get into it you could easily fill an hour or more just on that subject alone. But it's one to be wary of. It's not necessarily an interest for yourself, because commercial interest, it doesn't fall within that. It's when you take into account the balance of interests, whether that is legitimate to process the data in that manner. The next obligation is you may need to appoint a data protection officer. Now, this isn't the case for all companies. You definitely would need one if you're a public authority. If your core activities involve regular and systematic monitoring of data subjects on a large scale, and large there is really quite a vague term at the moment. There's not a huge amount of advice on that. Or if your core activities involve processing sensitive data, and that's a particular category of data that GDPR covers in greater detail and offers greater protection for. And those sensitive pieces of data are things like medical data, religious or ethnic background, and that type of thing, that are really extra sensitive to those individuals. Now, if you don't need to appoint a data protection officer, you're not in breach of GDPR if you don't. But I would always advise any company to put someone in charge, even if you don't name them the DPO, put someone in charge of data protection within the organisation, so that the obligation isn't passed around between departments and in fact nothing's ever actually done. Yes, just really to say the data protection officer can be outsourced, and this is something that is done, certainly is, I'd say, more common with companies outside of the EU, but it is necessary to be careful in that situation, because the DPO, the officer, needs to have a really good understanding of your business in order to do their job. And if they're an external appointment, you really need to make sure that they're being brought up to speed with everything that you do, so that they can fulfill that role properly. The next one is the data protection representative, and this is a slightly self-serving one. I'll put my hands up because this is what my company does. This is the sole purpose that we were set up for. And where you have a company which is based outside of the European Union, but they sell into Europe or they monitor people there, they don't have an office in Europe, they need to appoint a representative in the EU to represent their interests, and as a point of contact, essentially a European face to their organisation, so that the data subjects and the local authorities can raise queries with that data control or processor via their representative. It's not required for every company in that situation. If you're a public sector, or if you deal with what's called occasional processing, and again, there's really not a huge amount of advice on that at the moment. I generally say if European individuals make up more than a percent or two of your income as a business, then definitely you'll be risking falling on the wrong side of GDPR if you intended to rely on that occasional exemption. moving on, this is really, as I said, this is the main aim, is to have that person who can be contacted by those individuals. And I call this the hidden obligation. And it's unfortunate because the European Union has done a very poor job of advertising the GDPR requirements, certainly outside of Europe. But because this obligation only applies to companies outside of Europe, and because so many companies are basing their preparations on materials and advice that's coming out of European Union countries, they're not becoming aware of this obligation because it's not discussed within Europe. It's something that only applies outside of Europe. And I like to think of this as a European irony at its best, that we've not only placed this obligation on companies outside of Europe, we then haven't really told them a great deal about it. So yes, that's a European fault, I feel, and one that's, I think, going to cause problems for some companies, I think, reasonably quickly. The next obligation is to make sure you've got processing agreements in place. And this is really important between the data controller, who is usually the first point of contact with that data. It receives it in and it controls and decides what's done with that data. And then when it passes it on to the data processor, who's the next step down the chain, that data processor must be limited to what it can do with that data. There must be really strict limits and requirements on what they're permitted to do with that data, because as soon as they're given any discretion to choose how that data is dealt with, it's at that point that they potentially move over into controller territory themselves and face the extra obligations on that. So you need to have a processing agreement between controller and processor that needs to set out certain information, including the subject matter, duration, nature of the processing. It needs to say which countries those are going out, that data is going out to, and a substantial number of details need to be kept within those processing agreements. And again, you could spend a whole hour just talking about those. And in fact, yes, I'm going to go on to the second slide. So the other thing you need to bear in mind is, as a processor, and you'll have seen from Paul's diagram earlier, you can have a processor, but then you may have a sub-processor under them. So the controller may appoint a processor to do some work for them. That processor may then subcontract parts of that work themselves to another company. And there needs to be a pretty much identical agreement, a processing agreement in place between the processor and sub-processor, as was in place between the controller and processor, to make sure that that continual chain of custody and obligations in respect to that personal data is observed by all the parties who are dealing with it. The next one, I've touched on it briefly as well, is around international transfer of data. And this is really a key issue. Whenever you send data outside of the European Union, or wherever you pull data out of the European Union yourselves by collecting it from European individuals who are in Europe, you must make sure that there are adequate protections in place for that data within the country that it's going to. And the European Union have actually granted some countries what they call equivalent status, or granted an adequacy ruling. And that's Europe saying that we feel that your country has roughly equivalent rules and protections in place for data that we do here in Europe. And at the moment, you've got countries, Argentina, Israel, New Zealand, Canada, although only commercial organisations in Canada, the rules for public sector aren't as tough, and so they aren't actually granted exemption. And this exemption is really important. If you don't have it, then what you need to do is to be able to evidence in some other way that that data is being protected when it gets to your country and when it gets to your company in that country. And the way that people will usually do that is to put in place certain clauses and certain contractual rules. The US, and this is interesting, the US doesn't have itself an adequacy ruling because of the really quite disparate data protection laws in the US. That it's very much based on state to state and in fact sector to sector. So there's quite a good rule in respect of the medical sector, but in most other sectors, there's very little there. And what we've done historically between Europe and the US is we had something called the Safe Harbour, which was a self-regulated organisation which essentially said that US companies who would self-certify do provide adequate protections. And then along came Edward Snowden, and he pointed out that in fact, no, the NSA was looking at pretty much all of that data, and a lot of the companies that were protected by Safe Harbour or were supposedly adequate were in fact not at all. So Safe Harbour fell over after Snowden revealed that, and the new system that was put in place is called the Privacy Shield. It's potentially open to criticism under GDPR, and you can pretty much guarantee that that'll be one of the first points that the data activists and the privacy activists like Max Schrems will be taking up. But again, it's a process whereby US companies will self-certify to the Department of Commerce that they are adequate in respect of the data protection that they have for their clients' data. Next obligation is around your privacy notice. Now this is really key. This is around the transparency part of what Paul was talking about earlier. When you take data from an individual, you need to provide them with details of what you're going to do with that data. So you need to tell them who you are as a data controller, whether you use any data processors, how you would contact the controller, either through their data protection officer if they have one, or through a representative if the company's based outside of the European Union. You need to tell them how long the data will be kept, and you also need to specifically inform them that they have rights under this in respect of their data, and that they may object to the way that that company is treating that data, and provide suitable contact details to do so. And again, that's where the representative information would be kept. The subject access requests, this is something that you really need to prepare for in your organisation, because when they come in, and any individual in Europe may bring a request to you to say, I'm not sure that the data you have is appropriate, I'm not sure if that data is correct, I think it may be over the top for you to have collected details of all of my children's names simply to provide me with a newsletter. And it's through the subject access request mechanism that they'll raise those queries, and they'll send those either directly to the data controller or processor, usually through their data protection officer or their representative, and they're allowed to exercise their rights in that way. And when those requests are received by the company, it's very important to deal with them in a very quick way, and also to make sure that you have the processes in place so that you can do so. So have those processes in place, be ready for those requests, and have someone who's responsible for getting those answers back, because the need to respond is actually a 30-day deadline. So you need to be getting that information back to them really very quickly, or have a very good reason for not doing so. And you cannot charge for those requests. It used to be under the old regime that you could charge a quite nominal amount, to be honest, certainly not an amount that would compensate you for the amount of administrative work that's required to actually produce that information. But it was enough to at least discourage people or disincentivize people from putting mass requests in and using it really as a stick to beat companies they didn't like. Now, you can't charge for those dealing with those requests, but you can refuse excessive requests. So that if an individual is using it as a stick to beat a company and they're just putting request after request in, at some point that company can turn around and say, actually, no, these are excessive, and you're clearly now just abusing the process that exists. Notifications, the data breaches, and we looked at the data breaches, companies like Uber and what have you. There's a legal requirement to notify the relevant EU data protection authorities, and bear in mind there were 28 separate EU data protection authorities who may need to be notified within 72 hours of becoming aware of a data breach that affects the rights and freedoms of an individual. So if you have a breach and all of that data is so anonymized that there's no way that anyone could get any personal information out of it, then you may feel that you don't need to give a notification on that. But we'd always recommend that you sought legal advice on that, just to make sure that you're not perhaps seeing the rosier side of things and taking a risk by deciding not to notify. And if there's a particularly high risk to the data subject, so particularly if it's some of that information that's been lost is around particularly sensitive information, let's say medical statuses or things along those lines, you must also inform each of those data subjects. Now, it's not exactly clear where that line goes and what you need to do to be really putting those individuals at risk that you need to notify them. But again, it's something that's worth taking professional legal advice on if you find yourself in a potential situation of that. The data processing records, and these are really important as evidence, and really what GDPR wants you to do is to show you're working. So you need to produce documents that detail all the records and how you process data. They set out all of the information, and those need to be available for the authorities if they were to ask you for those. And essentially, there's a lot of detail that needs to go into those: when you're taking that data, what you're doing with it, how long you retain it, and what your deletion process is. So again, I really encourage anyone putting those records together to really put as much detail as you can, deal with every question that you can do, so that it's clear that you've taken your obligations under GDPR very seriously.
Okay, thanks, Tim. So now we get on to what to do. So basically, I appreciate to this point we've thrown a lot of obligations at you, and this section now is really about what you can do about it. So really, I go back to the first slide where I say the data marketer and the lawyer walk into a bar in Austin. That was a true scenario, and what we discussed was how hard it is for companies to turn data regulation into data compliance. And we said it just should be easier, but the problem is most small companies don't know how to do that. Data protection used to be the domain of big businesses, so the guys doing 27001 ISO compliance and all of that type of thing. So it was the banks, it was the big enterprises that were doing it, and so we said there must be an easier way to do it. So what we did on the back of returning from the States was we made a way of making it easy and created a free framework for anyone to access and complete at their own will. So what I'll do is I'll take you through what to do about GDPR compliance as a non-EU business, but frame it around the framework that we've created. So the first thing is to understand your risk. So the way I would do that is I would look at your web analytics, have a look at where your customers are coming from. I'd look at your CRM data, how many of your customers are in the EU. Is it 1%, 2%, 3%? What's your actual your risk going into this? And then using something like our system, you can just copy it into an Excel spreadsheet, or if you want, or you can use this system. I'll share the link with Kirsty, so she can push it out to everyone. So the first thing I suggest is appointing your team. So as Tim said earlier, DPO is not always necessary. An EU representative is more likely to be required. But having data protection champions within your business, I believe, is essential. So training people to be aware of data protection and to make sure that they're looking out for things in your business. So those people should be acting as they should be advocating for good protection over your customers' data and your staff's data. So just on that slide, the software provides a way of recording the name, email, and telephone number of those people, so you've always got it to hand. The next is compliance gap analysis. So we've created this using the ICO, the UK ICO standards, and we've done it for controllers and processors. But basically, we look against a number of criteria. So we're looking at transparency and lawfulness, individual rights, accountability and governance, security and international transfers and breaches. We basically set out what the requirement is and phrase it as a question. Does your company do X, Y, and Z? And then we provide a bit more detail if you need it. And you simply put a status next to it. So not started, work in progress, compliant, for instance. And going through this will allow you to understand where your risks are, understand where you're strong, understand where you need to do more work. And you can actually create an action plan out of it and share with stakeholders in the business kind of where your current compliance level is. The next thing is knowing your data. So any business should know their data inside out now. So there's a data map within this, and that data map is a process that we would typically run through with customers. So we'd look at every department in the business, and you'd sit down with the head of department or people in that department and say, okay, what data are you accessing to do your job? So the obvious one, employee data is the example, and financial information. Okay, what information do you actually need to run payroll? Well, I need their bank details, I need their social security number or their NI number, I need their address, and I need tax number, I need tax code, and you start logging all of that information. And then you work through things like the group of people it relates to, whether you've got a lawful basis for having that data. So I've got consent on this example, but actually that's a contractual obligation with that employee to pay them. You need that data. And then you also need to look at where the data is being stored and who has access to it. So in our business, for example, our payroll data, the Australian Tax Office, our accountants, our financial auditing company all have access to that information. So we list those individuals that have access to it. And then we also list where the data is stored. In our instance, Xero.com, which is a US-based warehouse. And so there is an international transfer, and we've actually checked that they're GDPR compliant and we're all good. So we map every single process in the organization like that. And what you find is that people have access to data that they don't really need. So you simply retract access to those people, and only people who need the access to the data to do a job have access to it by the time you've finished. So document processes, this is really simple. So by mapping your data, you're going to understand the various processes and sub-processes you're using. So a list of who those are and whether they're compliant or not, and whether you've got processing agreements with them or not is adequate here. Then process for data events. So as Tim mentioned, subject access requests, people could be asking for deletion, access to their data. They could be asking for an amendment. What this software does is it provides a form, an embedded form, which goes on your website in the privacy notice that the data subject can submit their request to you, and it guides them through the process. And then that pushes that request into this system, and you get a data protection query number, and it gives you a process for handling that. So as Tim said, we've got 1 month to deal with that, and this process takes you through every step of the journey and marks it off as complete when you're done. Then assets and processes. So by becoming compliant, you're going to be building up assets. So you can have things like privacy policies or privacy notices and amendments of those. You're going to be having complaint or data subject inquiry acknowledgement emails. All of these items should be gathered into one asset manager. So everyone in the organization knows where to go to access those assets, policies, processes. And then finally, training your team. So training is not a tick box exercise from our perspective. So as we mentioned, there's going to be more and more data collected on people over the coming years. And data protection, I certainly want the companies I'm dealing with to be aware of protecting my data. So data protection should be a cultural aspect to your business. It should be just something that happens naturally. So I would say train all of your staff, train all of your leaders, and make sure that you log that training and log the refresher courses. And again, what this will enable you to do is when the GDPR, when an authority comes knocking at your door, if you ever do have a breach, and you'll be able to demonstrate, right, okay, these are all of the actions that we are taking to protect the data of our customers. And just as a side note, I mean, I've spent 15 years now working in data, and I used to own a data warehousing company in the UK that handled government data and bank data and so on. And I've had 2 breaches in the past, and I have to say it's hard work. Okay, so when someone's on you, and it's an authority, the levels of information that you have to provide them and the timelines, we're talking, it gets tough quite quick. So I would say having all of this information to hand will put you in good stead to protect your business. And that's about it. So I know we're running tight on time, but we will open up to questions if Kirsty has got any.
Yeah, great. Okay. Thanks, Paul. So let's move on to the questions now. So I'm sure you've all got more specifics you'd like to know about your own businesses. So this is your chance to ask a question. Just click on the participants button at the bottom of your screen. And from there, clicking to raise your hand over on the bottom right. I'll then unmute you and you can ask your question. So I'll just give everybody a moment to find those buttons. Okay, hi Tony. Go ahead. No, maybe not. They scared off. Okay, I'll go with Mello instead. Go ahead.
Okay, I'm in Mexico. I have a travel blog hosted in Blogger by Google, and also a YouTube channel. And I wonder how much of all of this is applicable to me, because I'm not an organization, I'm just a travel journalist and blogger.
Absolutely, it's probably worth me picking that one up. So thank you very much for the question. And I do completely understand your point of view that effectively you're a blogger. I presume that you probably don't charge those individuals for access to your blog and your information. The problem that you'll have as an organisation is that you are processing the data of those individuals. And if any of those individuals are based in Europe, and even if they're Mexican citizens who are living in Europe, then you will fall within GDPR, and those individuals can look to enforce their rights on that information you hold. Now, if it's possible in some way to deliver your information in an anonymous way, so, and appreciate that will be difficult because it'll mean that you won't be able to have mailing lists and that type of thing. But potentially with YouTube, there may be a way to spread that information and potentially have YouTube keep track of the actual personal information without you holding it yourself. But yes, unfortunately, even if you're not actually earning any money from the work you do, if you're processing the data of individuals in Europe, then yes, GDPR applies to you and can be enforced against you.
Can I just add to that, Tim? So I would go to, you said you're using blogger.com?
Yes, I'm using Blogger by Google and also YouTube. And yes, I have some viewers from the European Union. And I should have somewhere a code for analytics that I'm not aware exactly which kind of data. But I mean, all of that is inside the Google environment for individuals.
Yeah. Well, I would check out their GDPR policy. Is the first port of call. So go to Google, take a look. So go to blogger.com, have a look at the their privacy policy, and then also if you've figured out that you are getting traffic from the EU, the next thing I would suggest is to have a look at what cookies are firing from your website. Are you remarketing people? Are you monitoring their behavior? And if so, you will definitely need to consider whether you what you can do about those cookies, whether you can restrict them in the EU. I think the good thing to kind of highlight here is that all of the large companies, marketing, advertising, Google, they're on top of GDPR, and they're actually doing. I've been surprised at how on top of it they are actually. In they're not just playing lip service. They're trying to evolve their products to comply. However, and I think I'm correct in saying this, Tim, this comes back to you, and you're accountable for this. It's your website. So yeah, check out the privacy policies of. Check out GDPR policy for blogger.com. Have a look at what cookies you're firing.
Okay.
Okay, thanks very much, guys. It looks like we probably don't have any more questions at the moment, but guys, as always, you can always email Paul or Tim if there's anything that you think of later. I'm sure you probably will as you get started on filling in that GDPR framework. And of course, this, as usual, this webinar has been recorded. It'll go up on the Travel Massive blog shortly, and I'll let you all know via email when it's up, so you can rewatch and send to friends. Whoever will also be impacted by GDPR, which is just about everybody who runs a website. So again, the emails are up on the screen there, and if you have any questions, you can always email myself as well at kirsty@travelmassive.com. So thanks a lot, guys, for the great webinar, and good luck everybody getting ready for that May 25th deadline.
Thanks, Kirsty.
Yeah, absolutely. Thanks, Kirsty, and thanks everyone for listening.